George and Alex Soros have their hands all over this. One of the plaintiff's top experts is Matt Barretto. He is a paid Soros operative and does not attempt to hide it. His CV, his resume, confirms it. He expects to receive $2.5 million from George and Alexander Soros. Nor is this something new. Soros has been pumping money into Barretto's UCLA Voting Rights Project for years, and this steady supply of money won't stop until 2026 at the earliest. Unsurprisingly, Barretto has been on quite a roadshow for years, parading across the country, opposing Republican redistricting. This is the tip of the iceberg. The lawyers are involved as well. To his credit, the lead counsel for plaintiffs does not try to hide it either. Chad Dunn acknowledged in open court he works with Barretto at the same voting rights project that receives Soros funding. On a silver platter, Judge Brown hands Soros a victory at the expense of the people of Texas and the rule of law. Judge Brown won't tell you that. I just did. These plaintiffs and their counsel and their experts are welcome in this court to present their partisan views, as is the state of Texas. But if we are to tell it like it is, we must recognize that the well-funded machinery that I have just identified is all about that political crusade that these parties are free to pursue under the First Amendment. And the public is entitled to know who's really driving this bus. The most obvious reason for mid-cycle redistricting, of course, is partisan gain. That is the core of this case, and I will repeat it ad nauseum. Judge Brown won't tell you that. I just did. The two-judge majority might even say, we don't need to wait for your dissent and wouldn't read it if we did. Here, that sort of happened. The entry on the district court docket brings up only Judge Brown's opinion. The reader has no access to this dissent without opening a separate, non-consecutive docket entry. So this majority has won in terms of diminishing the impact of the dissent and the public's access to it. In the interest of justice, one can only hope it is a Pyrrhic victory. When I was newer on the bench, a friend asked me, now that you've been a judge for a few years, do you have any particular advice? I replied, always sit with your back to the wall. Bam! That was just the preliminary comment. Now we get to the dissent. And this, again, is fire. Look at these first two sentences. The main winners from Judge Brown's opinion are George Soros and Gavin Newsom. The obvious losers are the people of Texas and the rule of law. Judge Smith writes, I dissent. In the interest of time, because he wanted to follow it as close on the heels of the majority opinion as possible, this dissent is admittedly a bit disjointed. Usually, in dissenting from an opinion of this length, remember, the majority opinion is 160 pages. Normally, I would spend more days refining and reorganizing the dissent for purposes of impact and readability. But that approach is not reasonably possible here because these two feckless judges in the majority have not allowed it. The resulting dissent is far from a literary masterpiece. If, however, there were a Nobel Prize for fiction, Judge Brown's majority opinion would be a prime candidate. Judge Brown could have saved himself and the readers a lot of time and effort by simply stating the following. I just don't like what the Texas legislature did here. It was unnecessary. It seems unfair to disadvantaged voters. I need to step in to make sure wiser heads prevail over the nakedly partisan and racially questionable actions of these zealous Texas lawmakers. Just as I did to the lawmakers in Galveston County in Petaway, another decision by the same judge who wrote the majority here that got overturned. I'm using my considerable clout as a federal district judge to put a stop to what I think are bad policy judgments. After all, I get paid to do what I think is right. Back to Judge Jerry Smith here in the dissent. He writes, in 37 years as a federal judge, I've served on hundreds of 3-year panels. This is the most blatant exercise of judicial activism that I have ever witnessed. There's an old joke. What's the difference between God and a federal district judge? Answer: God doesn't think he's a federal judge. Or a different version of that joke. An angel rushed to the head of the heavenly host and says, we have a problem. God has delusions of grandeur. The head angel calmly replies, what makes you say that? And the first angel whispers, he's wearing his black robe and he keeps imagining he's a federal judge. Only this time, the jokes aren't funny. Again, I dissent. Judge Brown, who wrote the majority, is no stranger to a spirited attack on a legislative body's exercise of its duly elected power to redistrict, before being roundly reversed by the Fifth Circuit sitting en banc. Judge Brown, imagining himself to be a legislature, imagining himself to be a legislature, wrote the following. This is, again, a case in which he got reversed. The 2021 redistricting process occurred within a climate of ongoing discrimination affecting Black and Latino voting participation. Black and Latino residents of Galveston County bear the effects of discrimination. Anglo commissioners are evidently not actively engaged in specific outreach to Galveston County's minority residents. Black residents in Galveston County are more likely to be arrested, and Black and Latino residents comprise a disproportionate percentage of jail and prison inmates. You know, more than 50% of the violent crime in America is committed by the 5% of the population that is young Black males. Might that explain a disproportionate arrest and incarceration rate? That has nothing, by the way, to do with voting. Continuing with Judge Brown, the plaintiffs here do not need, this is in that earlier case where he got reversed, the plaintiffs do not need to initially show that partisan affiliation does not cause divergent voting patterns. Practices exist in Galveston County, including voter purges and racially disparate access to polling places. It's stunning how completely the county extinguished the Black and Latino community's voice on its commissioner's court during redistricting in 2021. This is not a typical redistricting case. What happened here was stark and jarring. The commissioner's court transformed Precinct 3 from the precinct with the highest percentage of Black and Latino residents to that with the lowest percentage, and the judge doesn't like it. The circumstances and effect of the enacted plan were mean-spirited and egregious, given that there was absolutely no reason to make changes to Precinct 3. That was the case of Petaway, reversed. Again, same judge who wrote the majority here, Judge Brown. Petaway reversed by the Fifth Circuit en banc. Judge Brown concluding that the en banc fifth panel concluding that the district court, Judge Brown, was wrong. The en banc court remanded for the district court to consider the intentional discrimination and racial gerrymandering claims. Today, as a legislator/activist jurist, Judge Brown finds a likelihood of success on the current racial gerrymandering claims. In regard to the Galveston County matter, stay tuned for what Judge Brown will rule on remand. In regard to the preliminary injunction in the case at hand, read on. The ultimate question is whether unrestrained ideological judicial zeal should prevail over legislative choice. This, writes Judge Jerry Smith in the dissent, this is not my first rodeo. 14 years ago, dissenting from a flawed 3-judge redistricting order in this very court, I wrote the following. Reapportionment is primarily a matter for legislative consideration and determination. Accordingly, district courts are bound to follow the policies and preferences of the state legislature. In the reapportionment plans proposed by the state legislature, whenever adherence to state policy does not retract from the requirements of the federal Constitution. The aim of giving such due regard to plans proposed by the state is so the court will not preempt the legislative task nor intrude upon state policy any more than necessary. Justice Samuel Alito, in a recent debate discussing activist judges, explained that judges are not theorists or social reformers. Because the conscientious and well-intentioned majority has ventured far, he means the majority on that three-judge panel, has ventured far beyond its proper role, I respectfully dissent, in the hope that on appeal, the Supreme Court will provide appropriate and immediate guidance. 2 weeks later, the Supreme Court noted probable jurisdiction and set a special oral argument. Less than 2 weeks after the argument, the Supreme Court unanimously vacated the order from which I had dissented. In other words, the Supreme Court said, I, Judge Jerry Smith, was right. Unfortunately, here we go again. And he writes for the third time, I dissent. Speaking of fortune, Judge Jerry Brown writes in his dissent, just a few weeks ago, sorry, not Jerry Brown, Jerry Smith. Just a few weeks ago, the Fifth Circuit answered the main question at hand, holding that the most obvious reason for mid-cycle redistricting is, of course, partisan gain. The question for this three-judge district panel is whether the Texas legislature did its mid-decade congressional redistricting to gain political advantage, which is permissible, or instead because the main goal of the Texas Republican legislatures is to slash the voting rights of persons of color, which would not be permissible. Once again, here we go again. Criticizing the behavior of Department of Justice lawyers in the last decade's redistricting battle, I noted the following. It was obvious from the start that the DOJ attorneys viewed state officials and the legislative majority and their staffs as a bunch of backwoods Hayseed bigots who bemoan the abolition of the poll tax and pine for the days of literacy tests and lynchings. And the Department of Justice lawyers saw themselves, this would have been the Biden lawyers, and the Department of Justice lawyers saw themselves as an expeditionary landing party arriving here just in time to rescue the state of Texas from oppression. The Biden Department of Justice, moreover, views Texas redistricting litigation as the potential grand prize and lusts for the day when it can reimpose pre-clearance via Section 3 of the Voting Rights Act of 1965. Judge Jerry Smith continues in his dissent. Although the United States Department of Justice is no longer participating in this case, because, of course, now we have the Trump Department of Justice, the same attitudes about Texas Republican legislators have been reflected in the testimony of multiple experts and witnesses presented by these plaintiffs, occasionally, but not always, by their talented counsel and the statements of some parties. Because the obvious reason for the 25 redistricting is, of course, partisan gain, Judge Brown commits grave error in concluding that the Texas legislature is more bigoted than political. And for the fourth time, I dissent. It's all politics on both sides of the partisan aisle. George and Alex Soros have their hands all over this. One of the plaintiff's top experts is Matt Barretto. He is a paid Soros operative and does not attempt to hide it. His CV, his resume, confirms it. He expects to receive $2.5 million from George and Alexander Soros. Nor is this something new. Soros has been pumping money into Barretto's UCLA voting rights project for years, and this steady supply of money won't stop until 2026 at the earliest. Unsurprisingly, Barretto has been on quite a roadshow for years, parading across the country, opposing Republican redistricting. This is the tip of the iceberg. The lawyers are involved as well. To his credit, the lead counsel for plaintiffs does not try to hide it either. Chad Dunn acknowledged in open court he works with Barretto at the same voting rights project that receives Soros funding. Dunn is a respected attorney in Texas election cases, most recently serving as counsel in the Jackson case, in which the Fifth Circuit squarely declared the political nature of mid-decade redistricting. Mr. Dunn, along with his Voting Rights Project colleague Sonny Wachman, also represented the plaintiffs before Judge Brown in the overturned Pettaway case, which was overturned by the en banc Fifth Circuit. Mark Gaber also appeared in Pettaway and Jackson. He's the senior redistricting director at Campaign Legal Center, another Soros-funded group. It doesn't stop there. The Mark Elias Law Group draws from the Soros coffers too. Counsel for the Instant Gonzalez plaintiffs, David Fox, is a partner at Elias, which has collected more than $104 million from Democrat Party committees and donors, including Mr. Soros. Firm chair Mark Elias formed entities tucked inside large existing nonprofits that raise tens of millions of dollars from some of the richest donors on the left, including from foundations funded by Mr. Soros. On a silver platter, Judge Brown hands Soros a victory at the expense of the people of Texas and the rule of law. Judge Brown won't tell you that. I just did. What's this footnote 17? Footnote 17 reads, the point is that it's all about politics, and the federal courts are supposed to be the apolitical branch of government. You fight politics in the legislature and the governor's office. These plaintiffs and their counsel and their experts are welcome in this court to present their partisan views, as is the state of Texas. But if we are to tell it like it is, we must recognize that the well-funded machinery that I have just identified is all about that political crusade that these parties are free to pursue under the First Amendment. And the public is entitled to know who's really driving this bus. The most obvious reason for mid-cycle redistricting, of course, is partisan gain. That is the core of this case, and I will repeat it ad nauseum. Judge Brown won't tell you that. I just did. Relatedly, Gavin Newsom, governor of California, took a victory lap in Houston to celebrate the Democrat redistricting win with Proposition 50. Indeed, he did so on rival Governor Greg Abbott's home turf Saturday and called on other blue states to push back on GOP efforts to retain control of the House. And after the improperly premature issuance of Judge Brown's opinion, the Houston Chronicle pointed out that Gavin Newsom quickly tweeted, Donald Trump and Greg Abbott played with fire, got burned, and democracy won. This ruling is a win for Texas and for every American who fights for free and fair elections. Judge Jerry Smith here writes, that tells you all you need to know. This is about partisan politics, plain and simple. And for the fifth time now, I dissent. Regardless of one's political slant, Judge Jerry Smith writes in his dissent, it's obvious what Texas is trying to do in 2025. The Republicans' national margin in the House of Representatives is so slim that squeezing out a majority might even depend day to day on whether some seats are vacant because of deaths or resignations. In 2021, the Texas legislature, with both houses controlled by Republicans, devised a strategy of creating safe seats for both Republicans and Democrats, but with a decided majority of the state's delegation still Republican. Whether, as a matter of political clout, that was the wisest strategy is disputed, and indeed was fulsomely debated in 2021. Why are the Republicans giving the Democrats unnecessary congressional seats? Why are they being the nice guys? Do the Democrats ever return that favor? Of course not. In mid-2025, the strategy changed. The new plan was to make more seats winnable for Republicans by moving some Democrats incumbents from their districts and rendering other districts unwinnable by Democrats. That sacrificed the wider margins in some of the old districts, The trade-off is obvious. There is some speculation that this new strategy will backfire on Republicans in 2026 because if they do poorly in the midterms, the new Republican seats created in 2025 will be a Pyrrhic victory because they will lose elections in the closer districts. That is purely a matter of political strategy that federal judges have no business touching. The challenge faced by these plaintiffs and Judge Brown is to explain how it could be that the Republicans would sacrifice their stated goal of political gain for racial considerations. It makes no sense to advance the notion that the Republican legislature would draw districts for the purpose of disadvantaging racial and ethnic minorities if, by doing so, they lessen the number of new Republican seats they might gain. The plaintiff's theory is both perverse and bizarre. They actually contend that if the Republicans are sincere about gaining more seats, they could have drawn not 5, but 6, 7, or 8 additional seats, and that the reason they did not is that the real reason for the redistricting is racial animus. The absurdity of that notion speaks for itself. Yet it's all that the plaintiffs and Judge Brown have to offer to defeat the state's claim that the 2025 lines were drawn for the sake of politics and not race. That's the central dispute in this case, but the most obvious reason for mid-cycle redistricting, of course, is partisan gain. And now the 6th time, I dissent.